Now, to introduce this book, when we started doing, as it always happened that we have certain confusion, certain wrong confirmation because of news items available. For example, I often heard that there is no conviction from the Supreme Court on sedition law. And I have gone with that. And such this type of reports, we don't believe these type of reports have been published in like Law and then big magazines like Hindu. I have discussed this in the class. Let's see how these news are sometimes misleading. Because Kedarnath Singh case was a conviction case. He was imprisoned. Kedarnath Singh was convicted by High Court, by the trial court, by High Court, by the Supreme Court. But then there is a dominant narrative, and therefore we go with the narrative. So in the beginning, so this book here has 6 chapters. In the beginning, we have raised 21 questions. 21 questions. And I will take 2-3 minutes to discuss with you what are these questions, only questions. Is this law against democratic values? Is the provision of sedition under IPC itself seriously flawed? Or is its operation by authorities problematic, or is it both? Should the Parliament repeal or amend Section 124A? Why does provision of Section 124A does not use mens rea element? Is it a general intent crime or specific intent crime? Is it a conduct crime or a consequence crime or both? Why did not the Constitutional Bench in 1962 in Kedarnath Singh declare this law unconstitutional? What is the meaning of conviction of accused Kedarnath Singh in this case? Is the interpretation of Supreme Court progressive in nature? Is the interpretation seeking proof of incitement of violence or tendency to create disorder justified? Is actual violence or disorder a necessary element? Should it be decisive at conviction stage or at punishment stage? Is the interpretation given in the 20th century, in 1962 case, is still relevant in 21st century, or is a reformulation warranted? And you will recall that despite a Supreme Court Constitutional Bench pronouncement in Kedarnath Singh, Supreme Court has again accepted the constitutional validity of Section 124A. What is the impact of Naxalite movement, terrorism, disintegrating forces, which are traumatic threat to the survival of social order? And I had the honor to interact with Honorable Justice Mittal sir, and he was also raising these issues. Is the influence of technological revolution and social media a relevant consideration for examining issues involved in Section 124A? We have come from Stone Age to Space Age, Space Age to Cyber Age. Is it really relevant? What types of slogans are to be avoided? Which are to be admonished? And which type of sloganeering ought to be punished under sedition law? Should secessionist utterances be addressed through sedition law? And we all know that there is a case of Bayan Singh, and Bayan Singh case has been presented as if it has legitimized anti-India slogan, which is a complete misreading of the issue of Bayan Singh case. Is time right for judiciary to relook into prevailing sedition law and re-examine its constitutional validity? And we never thought that when we raised the question, the Supreme Court will really take this note of that. Yes, the time seems to be right. That let us discuss first 124 years. Should it be there, or should we make some reformulation? What was the intention of Constituent Assembly and the Parliament of India while delineating freedom of speech and expression in context of territorial integrity and defense of India? I would again refer to our interaction with Honorable Justice Mittal, who has just discussed with us that the American doctrine has not been accepted in India, neither by the Constituent Assembly nor by the Supreme Court. Is the US model of freedom of speech and expression applicable in India? Is Kedarnath Singh being rightly used to incorporate the American standard of free speech? In latter cases of Shreya Singhal and Arup Bhuiya is under consideration of the Supreme Court. Last two questions, how and when should the provision of Section 108 of CRPC, the one of the most neglected sections? Indeed, 108 of CRPC is a provision which can indeed answer all misuse under Section 124A. And there is no doubt that Section 124 is being misused, there is no doubt. I'd only say that sometimes it seems to us that the English were in certain sense better than some of us. When they incorporated section 108 in 1898, they incorporated 108 of CRPC has a bouquet of various provisions. 124A is there, 153A is there, 295A is there, and they say that for these cases, these all deal with free speech cases. For these cases, a show cause notice can be given to someone who is suspect, who is intentionally disseminating these type of materials, and take guarantee of their good conduct. So no FIR, first issue show cause notice, take guarantee, and if they resume, they recur, then in that case FIR will be there. This is general understanding, but please see what in 1898 the select committee has said, and we have not followed that. And this will be my concluding remarks. Regarding 108, when it was incorporated in context of sedition, the English said, we are bound to check such obnoxious conduct. But as a rule, the persons who are guilty of it are small and insignificant individuals. They may do enormous mischief among uneducated, foolish and ignorant people, but in themselves they are deserving of very little notice. It is absurd to deal with them by an elaborate state prosecution. We think in most cases, no prosecution at all will be required. Unquote. They themselves said that we need not to prosecute every person. But what is happening these days, that for a drop of a hat, 124 is being registered. What has happened in Bihar, and not only police officers, judicial officers. After NJSC judgment, Arun Jaitley, he was a minister. He wrote a piece in Facebook and he criticized NJSC judgment. And one judicial officer in UP, he has taken suo motu cognizance under 124A. So we cannot just blame police officers. Our judicial officers are sometimes so enthusiastic that they to go for registration or taking cognizance of 124A. So if I think that 108 CRPC is taken note of, then probably many misuse under 124A can be checked. So there are many things which we find it very much revealing, very satisfying for us. But this is the theoretical understanding. We have with us Justice Mittal, who has a practical understanding of all those things. So let us wait for his. Thank you very much.